But with that, there's a lot of recent developments affecting the entertainment industry, and this is going to be a survey of kind of everything that's going on now that's important. And I'm going to start with trademark because there's a very interesting recent decision on trademark. As a general comment on trademark, it is often confused with the rights under copyright, but trademark protects consumer confusion as to the source of a good or service. It is so. To pick a simple example, if you have a Birkin bag, someone's carrying it in a film, a woman's walking across the screen holding her Birkin bag, and you can clearly see the Birkin bag. That is not trademark infringement because no reasonable consumer watching that film would think Birkin, made the film. In contrast, kind of an interesting closer call is there was someone selling Birkin NFTs, and I think a reasonable consumer could believe that Birkin NFTs was sponsored by Birkin, and that therefore was trademark infringement and was held to be they were able to stop the use of the Birkin NFTs by someone that was not Birkin. The most important case, which is relatively recent, is the Jack Daniels versus Bad Spaniels case, which involved a Chewy dog toy that looked like a bottle of Jack Daniels whiskey. And the court held two very important things in that case. It held that, number one, trademark infringement, again, was only to protect consumer confusion as to the source of the goods. And second, it held that there's a famous case called Rogers, which up until that case courts had held that the use of a trademark in an expressive work was automatically protected, basically. And so even if it was the title of the film, even if it did implicate the source of the film, that it was protected by Rogers. The Supreme Court said, no, Rogers does not apply if the competing trademark is used to identify the source of the good. In my opinion, the Rogers test is dead now completely, and this is very important so that you no longer have any expressive work protection. And what gets conflated now is the issue of protection of the source of the good compared to the Rogers case. Let me just do an example, which is the most important, which is there's a recent case of Pepperdine University suing Netflix over a Netflix series called Running Point. And in the Running Point series, they use a trademark that Pepperdine has called Waves. And if you look at the two trademarks, the style of the print, everything's like almost identical. And Pepperdine was very upset at the way it was being portrayed, that it wasn't, reflecting their Christian values in the Netflix series. And so it's a perfect case and it was literally just a couple of weeks ago, perfect case to look at these issues. So question one, was it trademark infringement? And the answer was no, because Netflix was not using the trademark to identify the source of the series. It was using it as just in the series as they had teams that had that logo on it. So no trademark infringement. What was weird or interesting about the case is that the court then launched into a discussion of Rogers and said, oh, Rogers still applies. This isn't being used to identify the source of the film, and therefore Rogers protects it. I would suggest that the fact that it wasn't being used as a source identification was the end of the discussion. All right, that should have been it. Therefore, it's not trademark infringement, and therefore you don't even get to the Rogers test. And this is going to be a hotly debated issue, I think, going forward. And I just want to, I believe Rogers is dead. I think the test now is, does it identify the source of the good? If not, end of discussion. You don't need to rely on Rogers for Netflix to prevail. It just should have said end of discussion. there is a second prong of trademark which protects nationally known trademarks from being used by a competitor or someone else in a commercial manner in a way that dilutes the first trademark. And this is a great example to look at this case. So look at if we apply this to the Pepperdine case. So it has to be a nationally known trademark that is being used by Netflix in a commercial manner, and it has to dilute, which is called blurring or tarnishing. So question one, was Waves a nationally known trademark? I think not. And therefore I don't think that they would prevail on a dilution case. Second, let's assume that it was nationally known. Was it used in a commercial? Yes, because Netflix used it on the trailers, and you could see it in the commercials. That is a commercial use. Use in the film itself in the series is not a commercial use, but use on the trailer is. And then third is, let's assume both of those. So let's assume nationally known, commercial use. Did it tarnish or blur the trademark? That's the words that the courts use for dilution. And it could have tarnished it because the Netflix series has profanity and other, sexual innuendo, et cetera, in a way that Pepperdine is not happy with. So had it been a nationally famous trademark, or if it is, then they might have a case for dilution. And which is a whole separate, an analysis. But again, this isn't a Rogers test. This is just a separate test. In other words, I just don't think that Rogers applies at all. And next, let's talk about the next thing that's important is defamation. And a very important recent case there. Someone's asking, are there any slides? No, there's going to be written. Someone asked about written materials. There is a extensive handout that I've prepared that will be sent after the seminar. Defamation. The big issue here is, and it's going to be hotly contested in cases that are coming up, is the First Amendment protection for defamation, which is the actual malice standard established by Sullivan versus New York Times, which is still with us today. And why this is important is the Supreme Court just last week upheld or refused to revisit Sullivan versus New York Times, the actual malice standard. And what it says is that in a case involving a public figure or matter of public interest, a defense of the defendant is that they did not act with actual malice. And that the problem with this from whoever's been defamed is it's a subjective test. And I will quote from the most important case in the Supreme Court case that says, there must be evidence to permit the conclusion that the defendant actually had a high degree of awareness of probable falsity. So that even if it's wrong, and the perfect example is going to be Mike Lindell versus Smartmatic and Dominion. And and the problem is Mike Lindell is insane, and he probably really does believe what he's saying. And I can guarantee you that's going to be his defense, which is it's a subjective test. And Mike Lindell, honestly believed whatever I was saying, and therefore it's not defamation. And because you have to prove that he actually personally, subjectively knew or thought or reasonably thought that it was false. And that's a very high standard to meet. And there's been a lot of banging on this test. People were hoping that the Supreme Court would take it up, and they just declined literally just last week. Next is the next big issue for discussion today, and the hottest topic of all is artificial intelligence. And artificial intelligence gives a wonderful backdrop for discussing a lot of other issues that come up and we're going to, copyright, right of publicity, false advertising, all kind of things come up in AI. And the first and most important one, of course, is copyright. And there are now about 1 billion lawsuits that have been filed by anybody that has some copyrighted material that has been uploaded to some AI service. and everybody and their mother is suing and saying, you did not have the right to copy my information to upload it to your system. That the mere copying, the mere uploading was a copyright infringement. And there's the test for this is of infringement is the argument is fair use. The copyright, the AI companies are all arguing fair use, and they're all pointing to an old case called where Google was sued by all the libraries and said you can't. Google was uploading the live books and putting snippets of it, single pages up that you could search for, and all the owners of the copyright and the library sued and said you can't do that. And the court in that case said it benefits society, it's only snippets, it's fair, and all the AI companies are arguing that. Since the Google case, there's been a very important case that came out by the Supreme Court involving a painting by Andy Warhol of Prince that was taken from a photograph of Prince, and the court held that the painting of the photograph was not fair use, and it really established a whole new paradigm for analyzing this, I think, this precise question. And the test is now, excuse me, the test is now, would the owner of the original copyrighted material reasonably believe that they should be entitled to compensation based on whatever the other person was doing with their material? That is fundamentally the test. The court threw out what used to be called the transformative test, and as really, I think, looked at the reasonable expectation of the owner. If you apply that test to what is now happening with AI, it is undoubtedly the case that it is copyright infringement and that fair use will not apply, because the owners of the original material clearly think that they should be entitled to compensation. That's why they're suing. And anyone looking at it from afar would think that's a fair request. One second. Excuse me. In fact, there was a recent case a couple of weeks ago, 3 weeks ago, Thomas Reuters versus Ross Intelligence. It had extreme facts. It wasn't, again, it was an AI case. It was an upload, and the court held that it was not fair use. It did have extreme facts. There was direct copying. There was all, and the output was bad too. But that case, I think, is correct. I think that the uploading is a problem, and therefore the AI companies are going to have to get licenses from everybody that they want to upload their content, or going to have to pay some kind of damages for what has occurred so far. And there probably is going to be extensive licensing of underlying material to try to solve this problem, because it really is a significant benefit to society, but there's a cost for that. On the other side, there's now a lot of lawsuits on the output of AI. So we've dealt with the uploading side. Now AI spits out all kind of things, and there's a lot of lawsuits going on and saying you can't do that. That it looks too much like whatever you uploaded. There's really two basic claims. One is, I must be in there somewhere because you uploaded my information, and therefore I'm in the output somewhere. I think those claims are going to lose, because all art is based on prior art. That is, whether it's AI or not, everybody's influenced by what they've seen, what they've read, what they've watched. And so I would say all art to some extent incorporates prior art, even if it's all human created. So I think those ones will lose. The other ones that are winning and will win is if it's too similar to the existing work. And here it's a two-step analysis. Step one is what is created a derivative work that is based on the original work. And if it's too similar, and that it's really a rule with your heart question. Do you think that the new work is just too similar so that it's just not fair. Okay, that's step one. And if it's too similar, then now it's a derivative work. And now you've got a prima facie case of copyright infringement. And now your next question is whatever you're doing with it protected by fair use? And this goes back to the question of, is it fair? And there's a lot of factors, and you kind of rule with your heart depending on what they're doing. But I believe that under the Andy Warhol case now, that in most cases, if it's too similar, if once you find it's a derivative work, that it will not be protected by fair use. Because once again, the question will be, did the owner of the original work think that whatever you're doing with the new work, they should have been compensated? And the answer is yes. And it really, this Andy Warhol case changed the analysis. And I think that that's going to have a profound impact going forward. Next issue with AI is that, fascinating issue, is that you can't protect it with copyright. And the cases have said that, the Copyright Office has said that, and once you find that it can't be protected by copyright, it can't be protected by state law either, because the Copyright Act preempts state law. And so you can't send a takedown notice to a streaming service that's got it, because you can only do that for copyright. And so there's a lot of the litigation's been going on, but it's losing. Everybody who's saying everyone the first attack was, yes, you should be able to protect AI created material. Over and over, the courts are saying no. So I think that's going to be a loser. The second argument people are making is, I did something with it either in the process of making it or after. Like I told the computer exactly what to do, and I gave it such detailed instructions that it really was my work, or more accurate, or after the AI created whatever it is, I modified it, I did something. And what's the Copyright Office position is, whatever you did, you can protect with copyright, but not whatever AI did. So you have to bifurcate the output in terms of AI versus whatever the human did. What I think is more realistic is what's going to happen is that what I call the I forgot defense. And what everybody's going to do is they're going to register the AI output with the Copyright Office, and they're going to claim authorship, and they're going to say, good luck figuring that out, who actually did this. And what will happen as a result of that is there'll be, if people can figure it, that what'll happen later on is people will use AI detection technology to figure out if it was in fact created by AI, and then there'll be lawsuits saying no, it was, and there'll be discovery, and it'll be a litigator's dream. But for the main, that may work. I mean, that who's going to know who created it? It's actually very hard to figure out what was created by AI these days. It's not even AI detection technology can't keep up with the AI itself. So what my suggestion for companies that want to protect the AI output is simply have a human being with flesh and blood write the treatment, write the original outline of whatever it is for a film, particularly a treatment. And from then on, you can have the AI create the script, the movie, the everything. And by the way, while we're on this, AI can and will and is absolutely can create with almost perfect ability the script and the visuals and the characters and the music, and it's out there. I mean, if you haven't caught up with it, let me tell you, it's already there. And so the ability of AI to create perfect everything it unfortunately can outdo humans. It really can. And it's already, the truth is it's already there. So what you can do, though, is, again, you have somebody write the script, you have the AI create everything else. I mean, have somebody create the treatment, have AI create everything else, and then at least the story will be protected by copyright. You can register the treatment, and you can protect everything else as a derivative work based on the treatment, and including the film itself. So the entirety of the film itself will be protected. Now, you may not be able to protect the AI elements, so people might be able to rip off the visuals, they might be able to rip off elements of the story, but not the story itself. They would not be able to rip off the film and copy it and go sell it elsewhere. So that's what I think is going to happen as a way to protect on the AI front. Trademark. AI is certainly capable of incorporating Birkin bags in the content, and it does. And so you've got the same issues that we talked about earlier about you're allowed to do that as long as it doesn't confuse consumers as to the source of the film. So if you see output that's got Birkin bags or Mercedes driving across or whatever, that's fine. As long as it doesn't come out with a title, for example, presented by Disney, just to pick one example. That would, if AI spits out a film and says presented at the top, it says presented by Disney, that would confuse consumers as to the source of the good, and that would be a trademark infringement. There is a very funny anecdote on this, which is their Stable Diffusion, which is one of the AI companies, uploaded a bunch of Getty photographs, and the output actually said it was different photos. It was different. The photos were modified, but it said Getty Images on the output, and that obviously was trademark infringement because someone looking at it would see Getty Images. That was a bad idea of AI to actually copy and print out the source of the work. Had they dropped that off, they probably might have got away with it. Next big fun for AI is, which is the one of the huge battlegrounds, is right of publicity. And the problem is that AI can take me and make me go all the way from a perfect replica of me to a completely different version of an alien that has nothing to look like me. So, and that's that span in between that is troublesome. And so the general rule is that you have the right to sue somebody if they are using your name, likeness, or image in a manner that you have not approved. There's a lot of defenses to that, which we'll discuss. But if AI is creating, an actor is creating, George Clooney or anybody else, that is on the face of it a violation of George Clooney's right of publicity, and this has become extraordinarily hot topic. This also applies to the estate to people that have died, and their estates get to protect their right of publicity. In many states, California included. California used to have an exception for use of deceased personalities in connection with an entertainment or dramatic work, which is kind of a huge loophole. As of 2025, California has closed that loophole for any digital replicas of a deceased deceased celebrity. So that was intentionally to stop AI replicating deceased personalities for use in films or anything else. California also passed legislation that became effective in 2025 for that prohibited contracts that permitted companies to use somebody's image for digital replicas. So starting in 2025, again, you can't have a contract that says I can use your image to make digital replicas unless one of number of exceptions apply, and there's some pretty big exceptions. One is if they're a member of SAG, because SAG has its own protections we'll discuss that or give a lot of protection. And most importantly, really, if they're represented by a lawyer and the contract's clear and they sign it, then all bets are off. And then there's some other big loopholes, like if the digital replica is used in a way that does not replace work that the person would otherwise have done. So there are a lot of exceptions to that to this new California rule. One of the problems with the California rule for both of these that I've said, the estates and the individuals, is that it only generally protects people that reside in California or that resided here at the time of their death. And so just to pick one example, Gene Hackman would not be protected by California law, even if the exploitation occurred in California, because he'd have to go look to the laws of his residence, I think was New Mexico. The other problem, and this is the big one with all of these issues, is that it is not a right of publicity is not a federal rule. It's a state by state, and many states have very different rules. Some states look to the residence of the plaintiff. Some states look to the point of exploitation. And so it's really chaos depending on what state you're in, who's suing, what court you're in front of. And then to make it even worse, there is various states have various defenses. Some states have a weird defense that says if it's an expressive work, it's protected. Some states say, like California, if it's transformative, it's protected. And then some states say that if it's in a work that's protected by copyright, that it's allowed because of copyright preemption. And I will tell you, the law is in chaos on this issue, and it needs federal legislation in a big way to resolve the conflict between residence versus point of exploitation, and to resolve all these various defenses, some of which are just bogus, like the copyright preemption is just clearly a bogus defense, but some states follow it. And it's going to take ultimately federal legislation to resolve this. And I'm just going to read a question. So, again, if you can keep them short, it'll be easier for me. Input issues will lead to AI companies having to obtain licenses from producers. If that is the case, then why won't licenses be written to solve the output issue as well? Yeah, I agree. So the question somebody's asking is, if there are licenses for the input side, won't they cover the output? And the answer is absolutely. Of course, they'll cover both. And that is obviously the solution for the AI companies, but it does require getting licenses from the owners of the content, and that is going to be a major undertaking. Artificial intelligence regarding, and now another claim is defamation. And there have been defamation claims made regarding output of artificial intelligence that has said some false, nasty things about people. And there are people winning on the defamation claims. The interesting issue that has not yet been litigated is because so far it's been private individuals, but if the defamation is regarding a matter of public interest or is regarding a public figure, then you have the actual malice defense of that the person saying it, did they actually believe it? And so now the question is, for AI, are you asking the computer, hey computer, did you actually believe that false thing that you said? Because it's a subjective test, and the AI computer is going to say, yeah, I believed it. I was hallucinating, but I believed it. And so that'll be, stay tuned. This is going to get litigated, I guarantee you. And it'll be interesting to see how that comes out, because one would hope that would not be a valid defense for an artificial intelligence to be running around committing defamation that it believes, but is false. Next, false advertising, unfair business practices. We'll put it in the broad context of, is AI committing fraud? And an interesting case that involved this, not with AI, but was similar, was Sony released a record that was supposedly by Michael Jackson after his death, and it was supposedly unreleased tracks by Michael Jackson. And one of our erstwhile associates sued and went all the way up to the California Supreme Court, and it held that that was an unfair business practice, and that the Sony was by putting that out as a Michael Jackson thing was committing an unfair business practice and therefore was civilly liable. That is the same issue that's going to come up with AI, because AI is creating all kind of content that appears to be something that it's not. People are definitely going to be suing, so saying it's an unfair business practice. The question is, do they have standing? Do they have damages? But that is no question that's going to be a hotly litigated issue. What do you do as a distributor when you're handed a film or a script and you're not sure whether it's protected, whether it was created by AI? And the answer is you're going to get reps and warranties. You're going to get indemnities from everybody. You're going to have them swear in blood that they wrote it, that they did it, that it's not created by AI. And you're also going to use AI detection software to try to cover your bases. But are you, do you have a deep pocket to look, if you're a distributor, do you have a deep pocket to look at? Will there be insurance that will cover this? Because if it is created by AI, it will not be protected and other people can rip you off, and that will not be a happy day. If you have a claim, let's assume it's a defamation, right of publicity, all these claims, who do you sue? And do you sue the programmer that created the software? Do you create the owner of the computer that did the output? Do you sue the owner of the content, or do you sue the AI company that created it? So this is also on the output side. This issue of who you sue is going to be a significant issue. Another issue that comes up on this. If you want to avoid US law on some of it, you can create the content outside the US. So if you've got, this has already been litigated in the United Kingdom. For example, if you're worried about a copyright claim and you're an AI company and you don't want to run the risk of your upload being subject to a copyright claim in the US, what if you just go to Zimbabwe or you go to the Philippines or wherever there's not adequate copyright protection, and you set up your server there and you scoop up all the information in the world there, because the copyright looks to point of copying, and in that case the copying will occur outside the United States. And so you may be able to avoid some claims based on where you do the activity that is being complained of, and that'll in particular that's will be the case for copyright. What are the guilds doing about artificial intelligence? Well, the guilds are obviously all over this question. The DGA got a kick it down the road 3-year in their last contract. They basically said you can't use AI to replace a DGA member. That allowed it to that to be kicked down the road for 3 years. The WGA got a provision that said whatever you create with artificial intelligence is not considered to be literary material for purposes of compensation and credit. And all that means is that whoever next touches that material becomes the deemed author of it or writer of it for purposes of residuals and compensation. But the interesting aspect is, what if the studios just bypass writers altogether and use or strike that? What if they just create material treatment on up using AI? They're allowed to do that. They are technically allowed to do that, notwithstanding the WGA agreement, because all it says is that it's not literary material, but maybe their answer is who cares? And the reason they will care is because there's no protection for AI creating material. So what they probably will do is get a non-WGA writer to write a treatment or a screenplay, if they can use some affiliate that's non-WGA for example, to pick it up, buy it from somebody else, and have AI create everything else. And that way you get the treatment protected by copyright and you get everything else created by AI. And technically they can do that. It'll be interesting to see if they actually attempt that. It would not be nice. And WGA will not be happy with that. That's for sure. SAG is all over this question. In their last one, they basically have, you cannot, I will say that if bottom line really is you just can't do this. There's significant restrictions for using a SAG actor and creating digital replicas of them. There's limits as to what you can do with it. There's limits as to that you have to pay them and compensation. The open issue and the big issue is non-SAG actors to create the ability of a studio and AI to just create synthetic, completely created characters, and they can do it now. The SAG, because of the SAG jurisdiction over employees, really can't stop it. And there is a provision in the SAG agreement that says that if the studios do that, they have to negotiate with SAG to discuss reasonable compensation, and the compensation appears that it gets paid to SAG, and B, it's not clear what the reasonable compensation is. I'm sure the studios are going to take the position that no compensation is owed, that reasonable is zero. And so that's yet to be fought over. And I'm kind of standing by watching to see where that one goes, because they can now create completely synthetic characters that have no resemblance. What they're not allowed to do, and the SAG agreement specifically says that, is they cannot say, please have the characters look somewhat like George Clooney and somewhat like Brad Pitt and put them kind of together. You're not allowed to, the studios are not allowed to ask AI to create a character that resembles attributes of existing actors. The question, of course, will be when ones are created by whole cloth. By the way, this is already coming in the social media influencer world. There are already now completely created by whole cloth influencers, and they're doing fantastic, by the way. They're making a lot of money for the creators, and they have personalities, they have storylines, they drive fancy cars, they wear sexy clothes, they go to parties, and it's getting very hard to tell them from a real person. They have thousands and thousands of followers, hundreds of thousands of followers. They are making money. And so you can imagine that this is going to come for acting, that they're going to create a backstory for an actor that's got whatever their backstory is. But it'll be an off-screen persona that will and they will have that person, that character, appear in multiple movies so that people say, oh, I want to go see Tom Smith in blah, blah. They'll recognize Tom Smith. I think that is undoubtedly that is coming. And again, the question how you protect that, I think that you will be able to protect that with trademark if done right. You can't protect it with because of copyright. You can't protect it with copyright, but you may be able to protect those kind of characters with trademark, because I think that is the way that you protect it. Moving on, I'm just going to read a question that's fortunately short. If a human writes the treatment, AI wrote the rest, which is much different, how much of the final film is protectable? Okay, so whatever's created, if you've got an element that is created by a human and some element that is created by AI, only the element that is created by the human is protected, not the element that is created by AI. So if a human writes the story and AI does something completely different, the completely different is not going to be protected. It is only going to be the original story that is created by a human that will be protected. Onward. I want to talk about some important things that are going on in the outside of AI. And I want to talk about, the first one I want to talk about is some tax issues. And they're not boring. The first one, and most importantly, is Section 181 of the Internal Revenue Code. And there's many people are getting pitched on raising financing using Section 181. What it says is that you get to deduct the cost of making a film in the US for the first $15 million. And there's a similar code section, 167K, that says you can deduct the entire cost of the film when you release it. And there have been several companies running around town that have been raising money from investors that are investing in films based on these two code sections, and they're pretty well known. I won't name names, but they're pretty well known. Two things are going on. One is the Department of Justice is now bringing there's a pending criminal grand jury investigation of one of these companies and for tax fraud. And I will tell you, it is tax fraud. It is absolutely no question tax fraud. I've been writing about this for years, and the government is now on it. That's step one. So there are going to be criminal prosecutions, and the question is, how far does it go? Particularly will they go after the producers for aiding and abetting? That's now a significant risk. So I've told all clients, do not accept any more financing on a 181 deal because of these pending criminal prosecutions. Second is there are now civil lawsuits going on, and that the investors who are being denied their deductions are now suing everybody that they can find and going all the way to no question, they're looking for any deep pocket they can find. So they are definitely going after they've threatened the producers, they're threatening everybody, but that for both of those reasons, you should not be doing any more Section 181 deals or 168K deals. The reason they don't work, by the way, is that the losses are called passive losses and can only be deducted against a very limited category of income that most people don't have. And the only way you get through that is pretending that the investor is an active producer on the film, which they never are. So that's the fraud, number one. And number two is they try to deduct the entire cost of the film by pretending that they put in a few bucks and try to deduct the entire cost by pretending that they have some liability on a debt, and the debt always magically disappears, and that is also fraud. So those are the two fraudulent aspects of this that get hung up. Next big tax issue to look out for is that everyone in California almost everyone that works on a film is an employee. If they're working as an individual on a film, whether they're an actor, director, anybody, you should assume they're an employee and therefore subject to withholding, and therefore subject to the whoever pays them, the company that pays them, has to withhold. And more importantly, any individuals at that company that had control over that payment or including the president of the company are personally liable for that failure to withhold. And that failure to withhold is not dischargeable in bankruptcy. And this is a life and death matter. I have litigated this issue in California court, and I will tell you, it is a scary, unhappy day when you're litigating this on behalf of an individual that is personally liable that cannot avoid bankruptcy. So they cannot avoid it through a bankruptcy. So please look out for this. Please don't be aggressive on this issue and treat everybody as independent contractors. California passed a law last year that respects loan outs for the film industry. And as worded, it protects anybody who works even at a production or distribution company. And as worded, even if they work in the kitchen or somewhere else, like so in a secretary and so you can't read the law literally. The intent was clearly to protect at least above the line, probably below the line, people from allowing them to be treated as independent contractors. The issue to look out for is the federal side. This is California legislation. It doesn't apply for federal purposes. The federal position right now is to respect loan outs for above the line, but not for below the line. So when I'm representing a client, I do not suggest accepting a below the line person showing up with a loan out because of the risk on the federal side that there will be some hell to pay. So, because again, it's not dischargeable in bankruptcy. Next issue that's come up recently is there's been a number of companies that have taken a film and just put it on the shelf and not released it. And I keep getting calls from the press saying, was that done? Someone wrote an article and somebody said that it was for tax purposes, that they were somehow getting a tax deduction for putting it on the shelf. And that is not accurate. When you see an unreleased film, it is not being done so that they can deduct the cost of the film. It is clearly being done for the truth is it's being done for some accounting reason. For example, that it's before a merger or an acquisition, they want to write off the cost of the film for off the books, so it doesn't show up as a loss after the merger acquisition, or they're trying to clean up the books before the next year, or they're trying to run it through the balance sheet as what's called an extraordinary loss. But if you see that happening, it's being done for accounting purposes, not for tax purposes. Next issue I do want to warn people about is that in the film industry, everyone it's so common to use investment contracts. Somebody invests in a film, and instead of having ownership or a loan or a security interest, they do these investment contracts, and that leaves a world of uncertainty as to probably, for state law, that is probably a partnership, and probably therefore a general partnership, which therefore means the investor is now personally liable as a general partner for the debts of the film if things go awry. And so you really want to look out for that. And second, it's not clear. It leaves this uncertainty as to can the investor deduct their investment, or maybe they can't. I think the answer is they can't deduct it because they're not a partner. They're not a member of an LLC. And so all I would say to everybody is, please, if you've got investment in films, structure it as an LLC, make the investor a member, make sure that they get allocated their share of deductions, and they'll deduct it. They can deduct it under 181 to the extent they actually have an investment, if they have passive losses. And an LLC is very clear as to their limited liability, who's in control, who's doing what to whom, what are the tax implications. Do not use investment contracts. And by the way, on the producer side, if you get money under an investment contract, by the way, that's fully taxable the day you get it. There's no exception for it. You can't call it equity because it's not equity. It's not stock in a corporation or an LLC. So, and it's not a loan. And so you only have three choices. It's a loan, equity, or income. And the answer, if you get a big investment from somebody up front, that's income and you're taxed. And that is, not a happy day. So from the producer, they shouldn't be doing it either. I see the similar issues. The similar issue coming up with when you get a deposit from a distributor, that's also taxed up front in most cases. And the IRS and the courts also say that if you sell production subsidies, you're in Georgia, Louisiana, and you get production subsidies during production, they say that's taxable. And everybody ignores it so far. And I haven't seen many audits on it, but the ones that do go to court, the IRS and the courts have said that's taxable when you get it. And you should at least be aware of it. You should, not try to ignore that. And next issue, I get a lot of questions on, if I sell my film, do I get capital gain treatment? Or if I sell my rights to the film, do I get capital gain treatment? And the answer is, it's hard. You have to sell an entire territory, all rights within a particular country in perpetuity. A license doesn't cut it. But if you actually call it a sale and you sell all the rights within one territory, you might be able to get capital gain, which is, of course, taxed at a much lower rate. Next is, let me talk about choice of entity in the film industry. I get this question a lot. What should I use for a loan-out corporation? What should I use for production, distribution? If you have a loan-out corporation, that you should be using if you have a situation where an individual can be a loan out, an actor, producer, above the line, basically above the line person, they really should be using an S corporation. That is, not a C corporation. They should be using an S corporation. That way you don't run into the problem of double tax. You don't have to worry about as the double tax if you don't pay out reasonable compensation. And more importantly, if they have services outside the United States, they will get a foreign tax credit that they will offset their US taxes. So as opposed to a C corporation where you cannot do that. Next, film production and distribution. Almost always you want to use an LLC and not a corporation if you're doing film production or distribution for several benefits. One is that you get the investors can deduct their losses as they go, or at least at some point they'll be able to deduct it if they either have passive losses or once they start getting income. They're very flexible. It avoids double tax. And you can do special allocations. They're very simple, very flexible. The agreements do not have to be that long. And that's without question the way to go. If you have a foreign person or foreign company coming into the United States, it is much better to use that's when you use a corporation, because a corporation will avoid the foreign person being subject to tax in the United States. And if you've got or directly, the U.S. corporation will pay tax, but not the foreign corporation or the foreign individual will not have to file tax returns in the U.S. and will not be subject to, in particular audits and California tax, et cetera. Which is extraordinarily painful. And then if you have in U.S. investors and a foreign investor, have the foreign investors come in through what's called a feeder corporation. So they use a corporation and they invest in your LLC. Your U.S. people come in and they invest directly. Next, let me see if there's questions. Oh, sorry. Do actors who have to have back-end deals on unreleased films have a potential cause of action against the studios? Do actors who have back-end deals on unreleased? Oh, there's a question. Yeah. Yeah. So the question that was asked on it, because I mentioned about unreleased films not being done for tax purposes, I think the short answer is there is an implied obligation of good faith and fair dealing when you do a deal with a studio and you trade off you get lower upfront compensation in exchange for a bigger back end, and then they don't release the film and you don't get it. I think you have a claim. And I think you have I think Scarlett Johansson brought this claim on a similar fact pattern and won or settled. And so the short answer to that question is, I do think that they have a claim. And second. Next thing I want to talk about is briefly update on the securities laws. Every time that you raise money for a film, almost inevitably, you are issuing a securities, even if it is a simple investment from your mom into your film. That is technically a securities, and so many people overlook this and don't comply with the securities laws. And I had one client that was doing it off on their own, and I ended up getting criminally charged because it is a violation of the securities laws. They do take it seriously, and particularly if things go south, two things will happen. One is that the individual behind this offering, the producer, will be personally liable to repay everybody's debt, everybody's investment. And second is that you can be criminally prosecuted. So please, please, please pay attention to the securities laws. And it's very simple to comply with it. Step one, make sure everybody is an accredited investor. And that means that they have over $1 million of net worth, excluding their home. That's the simple way to meet it. Just make sure they have it. And under a recent SEC ruling, you can rely on the person can tell you, I am accredited, and you can rely on that. And if you do that, you are allowed to advertise your offering. And what I'm amazed at is that so far nobody has I haven't seen any advertised for a film offering, even though you're allowed to do it. Like I haven't seen it in the Hollywood Reporter or the Variety, and I don't understand why people haven't done it. Because as long as you make sure that everybody's accredited, and as long as you disclose all material facts, which is pretty easy to do, in a simple private placement memorandum, it doesn't have to be long. You can comply with the securities law. So I just A, make sure everyone's accredited. B, do some simple disclosure document, like usually a private placement memorandum, and it does not need to be long. It can be very short and very simple. And C, file a Form D with the SEC. It's a very simple form, but you do have to do that. The SEC wants you to file a Form D. It's a pretty simple process. And then so if you do this right, it's an LLC with a simple LLC agreement, not an investment contract. You just comply with the securities laws. They're accredited, private placement memorandum, file a Form D. Please, keep your nose clean so you don't end up what my other client did, getting criminally prosecuted for doing an offering where I was not involved. And last but not least, I want to give you an kind of the PR part of the show. If you want to be added to my email list, all you have to do is send me an email an email to smoore@ggfirm.com and just put add in the subject line, and I will add you to a newsletter that I do. And if you don't have it, you should have my book, The Biz. And it's on Amazon, and it covers everything we've talked about today, plus a whole lot more. And it's very popular. It's in its 6th edition. It's let me see. With luck, I can actually pull it up on my screen. Let me see if I can do that. Hold on one second. And share. Let's see if it do that. And with luck, hopefully the book will be there or somewhere. Maybe I can pull myself away. And anyway, and then third, there we go. Hopefully you can see it now. And so that's my book, The Biz, that's on Amazon. And then let me stop share. And finally, I have a YouTube channel that you can find if you go on Sky Moore Attorney altogether. Just, it's SKY Moore, Moore Attorney on YouTube. I have an entire channel that is the course that I taught at UCLA Law School and the UCLA Business School. And so you can choose a topic because it's broken out by subject. And then I have a Forbes blog that I do monthly, and covers all recent things that are coming out and new developments and whatnot. And then I welcome everyone to call me with questions. I'm more than glad to answer questions. I welcome them. I don't charge for it because I love hearing that what's out there. And so the more I hear what's happening in the world, and causes me to think about it. So please feel free to call me with questions. And let me see if there's anything else. There we go. Yeah, and there we go. So I think we've hit our 3 o'clock, and I've kept it to an hour. And any recommendations for blog, social media? There we go. Somebody asked about what to keep up with for current developments, and there you go. I would say my Forbes blog, my Forbes article, the book, and then you really just stay up to speed. Anyway, so thank you all very much for coming. I will keep this on track for the 3 o'clock, and have a wonderful day. And please, again, feel free to call me anytime with any questions. Thank you so much. Cheers.